So Samridhi, so we are taking your mock interview today,
Yes,
and this is for Delhi Judicial Services. Uh, let's start with your introduction first.
yes, sir. So my name is Samridhi Talwar. I'm from Delhi. I did my schooling from Mount Carmel School, Anand Niketan. I completed my schooling in 2017. After that I did my BBA LLB from the main campus of the Guru Gobind Singh Indraprastha University. I completed my LLB in 2022, and ever since then I've been preparing for judiciary.
Okay. So Samridhi, have you taken any other judicial services exam apart
Uh,
from this present Delhi Judiciary?
Yes, sir. I had first appeared in the Chhattisgarh Judicial Services in January of 2023, and after that the Himachal Pradesh in July. I could not qualify both. After the Delhi Judicial Services, I also took the Rajasthan Judicial Services 2024.
Okay.
Yes.
So what was the result in Rajasthan Judicial Services?
So I've qualified in the Rajasthan Judicial Services.
Okay. So if in case you're selected in Delhi Judicial Services, so don't you think that it will going to affect the like you'll be leaving in that case I presume that you'll be leaving Rajasthan Judicial Services, right? And if in case you always had a plan to join Delhi Judiciary, then there was no need to maybe appear in Rajasthan, or maybe this will actually waste one of the vacancies in Rajasthan Judiciary, which could have been given to the some other candidate.
Yes, sir. My plan was always to do Delhi Judicial Services. However, because there is so much competition and the result of examinations is very uncertain, that is why as a backup, I did appear for Rajasthan Judicial Services. So just in case I do not qualify the Delhi Judicial Services this time, I will have Rajasthan as a respite, and after which I can reappear for Delhi if need be. And also, sir, I also use, because it is easier to study when you have a goal. So because the Delhi Judicial Services means was the result was not certain when would it come, so that is why I use Rajasthan as a goal, so I could continue to study, and because of the grace of God I did qualify. Yes, sir.
So you're saying that just in case you're not able to qualify Delhi Judicial Services, you can reappear in this exam. There might be some student in our in the present interview, who is at the verge of maybe he or she might be at the age of 32, and that might be his or her last attempt. So do you think we should prefer that student instead of you?
No, sir. I do not, although I cannot speak to the competence of any other student, but I believe that my track record shows that it is very consistent. I have been selected in Rajasthan Judicial Services, which means that I have merit, and I'm very passionate to be a judge in Delhi, because this is where I belong from, this is where I have a home, I have a community, and this place has given me a lot, and so I would like to give back here. And since I have qualified this examination at a younger age, I believe I will be a better candidate than such a person.
Okay. So do you think experience is more important than the young age? Because you're not having any practical experience, I believe.
Sir, although I have interned during my law school at as many places that I could, I think both are important. However, I believe that in this case, age might be a better factor, because if only experience mattered, there would not be a training. But after selection, every candidate goes through a year of training. So I believe my young age will make up for the experience in the training itself.
Okay. All right. Perfect. So I think now the other interviewers will going to ask you some questions.
Okay. So first of all, congratulations
Thank you, sir.
for qualifying mains. Okay. So just tell me that you are talking about the things that the experience is also required and the merits are also required. So as you know that Madhya Pradesh has introduced some more criterias. So what do you think about it?
Sir, I think it is a fair criteria, because it gives opportunity to both kinds of students who have experience, 3-year experience, as well as students who were academically bright and have excelled in their law school. So I think it is fair.
No, definitely it is fair, but some law schools might be giving a liberal marking scheme, but some are strict. So how do you compete about them? Like how is there a fairness between the marks parity?
So I believe since all the law schools are subject to bar council guidelines, there is a sense of uniformity. I would like to believe so. And also, sir, if a candidate because of their college not getting sufficient marks is unable to get the qualifying amount of marks, they can practice and then appear for the judicial service examination.
Okay. So here you mentioned that are you a net qualified student?
No, sir.
Okay, so I thought it is a net qualifier. Okay, so what was your topic of dissertation in LLB?
So it was regarding space law,
Okay.
the legislation and the recent developments in space law.
Okay. So what were your findings?
So it was a doctrinal research. So I researched on the various upcoming space law topics such as space tourism, such as certain liability convention, how liability is decided in space. I researched on these things, sir.
Okay. So do you know about what is the name of company that the Jeff Bezos, who is the founder of Amazon, owns?
Blue Origin, sir.
Blue Origin. Okay. So recently there was a trip to space by I think Elon Musk. Yes. So were there any person from India?
So I'm not aware. I apologize.
Okay. Okay. So you have also mentioned that Honorable Justice B.V. Nagaratna J is your favorite judge. So what do you think about her judgments? Because I have seen a plethora of judgments that she was dissenting in every judgment. So don't you think that she's setting a different example out of nowhere? So what are your opinion about it?
So I believe dissent is very important in our judicial system because it shows a new line of thought or another idea that could be incorporated. And in fact, our constitution itself empowers judges to dissent and give a judgment for the same. And there are various landmark dissents that have now become the norm, such as Justice H.R. Khanna's dissent in ADM Jabalpur versus Shivkant Shukla, which is now celebrated and is the law. So I don't think the fact that she has been dissenting in a few judgments is problematic. I believe that is actually showing that if one has a different opinion which one can back by law, one should say it and one should voice it out.
No, but in every judgment she has been dissenting. So is there any personal vendetta or anything?
So
Do you think so?
I don't think so, sir. Her dissents that I have gone through,
Yeah.
I think are backed by law and I think have logic in them, sir.
Okay. So who were the dissenting judge in the case of Sabrimala?
Sir, Justice Indu Malhotra, Honorable Miss Justice Indu Malhotra. I apologize.
Yes. Okay. So just tell me about what is the group of companies doctrine?
Yes, sir. So the Cox and King case of the Honorable Supreme Court affirmed the group of companies doctrine, which says that even though a company or an entity, which although is not a signatory to the arbitration agreement, but by their conduct or by other documents, it shows that they are acting in consonance, they can also be held liable in the arbitration agreement, can be deemed to be a party.
Okay. So what were the earlier findings by the Supreme Court on this doctrine? Do you know?
So earlier there was a case, I can't recall the name of the case, I apologize, but the Supreme Court had held that the Supreme Court had upheld the doctrine but in a different manner, where they had held that the group of companies doctrine will only apply to those companies that have implicitly or explicitly related themselves to the arbitration agreement. Whereas in the Cox and Kings case, the Supreme Court broadened the ambit and said that these are not parties who are claiming under the signatories, but rather are independent entities that might have been affirming to the relation of acting in consonance with them, with the signatories.
Very well. So who is the current acting Chief Justice of Honorable Delhi High Court?
So Honorable Acting Chief Justice Vibhu Bhakru.
And is there any new appointment for the Chief Justice post?
I'm not aware, sir. I apologize. I'll read upon
Okay.
it.
So did you read newspaper?
I did, sir.
Okay. Today's newspaper also?
Yes, sir.
Okay. So what were the main news from the newspaper today?
So the main news was that the Israel cabinet has affirmed the Israel and Gaza truce. That is one that I can recall, sir.
Okay, so who was the mediating countries?
So, I can't recall that, sir. I apologize.
Okay, it is US and Qatar.
Yes, Qatar.
Okay.
Yes, sir.
So, do you know about uh, there was a genocide convention which was issued by one of the country. So, do you know about who was that country? When there was a Philistine conflict and Gaza conflict was going on, then who was the country which has issued that genocide convention has been breached by Israel?
So, South Africa.
Okay, very well. So, is there any hobby?
Yes, sir. I enjoy cooking and I enjoy reading books.
Okay, so is there any recent book you have read?
Yes, sir. There's one book that I reread. It's called Grit by Angela Duckworth.
You reread it?
Yes,
Okay. So, did you not read any other book that it excites you to read a new book?
Sir, I did read another fiction book. This book was a non-fiction book. I read a fiction book also. It was called called Ove by Frederick Backman.
Okay, so can you brief out what was the?
Yes, sir. The fiction book is about an old man who loses his wife, and after that he loses all sense of purpose in life, and so he tries to take his own life. And while he's doing it, while he's trying to do that, he discovers slowly the importance of community and how even though we're all imperfect, there can be happiness sought and there can be a sense of community that can be formed, even though we think we're not worthy of it.
Okay, so you have already researched about space tourism. So there was a recent development. I think that was a remarkable achievement made by ISRO, our research company. So what was that?
So the SpaceX mission was a success where the docking procedure was done by India, and India is one of the 4 countries now in the world that has done it.
Okay, so what is the benefit of it?
So the docking has a lot of benefits. One is that it will enable India to make its own space station in space because of the docking technique. Also, this is the first mission where an absolutely private entity was used to assemble the spacecraft, which shows that there is a growing public-private partnership in India regarding space.
Okay, very well. So there was a case that where Saif Ali Khan, the renowned actor, has been stabbed. And now Mumbai police has made 20 investigation teams to search about what has happened. So don't you think that it is a mockery of rule of law where a poor man will be given a one investigation officer and you are making 20 investigation teams for one person. So what is this parity? Isn't it a mockery of rule of law?
So, although I'm not aware of the entire news, I was just aware of the headline. I'm not aware of the entire news, but from the information that you have supplied, so I think that it's not a mockery of rule of law, because if somebody at such a high level and at with such security is suffering through something, then there might be such investigation might be important, because it shows that a common man could be suffering through even more. So if this has come into limelight now, although it should have come into limelight before when a person who's not of sufficient means suffered, it should have, but if it is coming into limelight now and if we can investigate, I think it will benefit everybody.
Okay, so a last question from my side. What is the doctrine of contra proferatum? Yes.
Yes, sir. So the doctrine of contra proferatum is a doctrine that is used generally in contract law, which says that if there is a term in the contract or the term in an agreement which is created by one party and completely favors that party, then the other party will have, and there is some subject of some discretion can be exercised, then the party against whom the entire doctrine is the entire agreement is can decide in their favor.
Are you sure?
Not entirely, sir. I apologize.
Okay.
So, hello Samridhi.
Hello, sir.
I want to know, what is your favorite subject?
So I've prepared all my subjects, but I enjoy Indian Evidence Act quite a lot.
Why is that?
So because it applies to both civil and criminal cases, so the same sections apply to different provisions, and I can see the application in every single case possible.
Okay. Is it an exhaustive law regarding law of evidence?
No, sir.
Why would you say that? Like, because do we have any other procedures for evidence in any other law?
Sir, although there are certain laws that provide for their own procedures, for example, Code of Civil Procedure prescribes that examination in chief shall be on affidavit only. There are also principles of natural justice that are though not codified but also govern the procedures in court, including taking of evidence.
Okay, but now evidence has been replaced by the new
Yes.
Bharatiya Sakshi Adhiniyam. What do you feel the difference in between these two enactments?
Sir, then there are a few differences. First being that digital evidence has been given a lot of importance. Digital evidence has been given the status of a primary evidence. Apart from that, sir, the Indian Evidence Act Section 27 provided for an exception to confessions recorded by police or given in police custody. That applied to Section 24, 25 and 26. Whereas now in Bharatiya Sakshi Adhiniyam, the protection only applies to confessions that are given in police custody or to a police officer. These are two
So,
changes.
would you agree with this change? Is it for the better or worse with respect to the jurisprudence behind the same?
So I believe it is for the better only because Section 24 of the Indian Evidence Act already has Section 29 by which judge has a leeway, where judge has discretion to see if such a threat, inducement or promise is in place or not. And also Article 20 Clause 3 also protects an accused who is making such a confession.
Okay. And when you talked about this principle of natural justice, do we find any other enactment where you can see that yes, principle of natural justice has been incorporated?
So one law that I can recall is the Arbitration and Conciliation Act, which says there will be equal treatment to parties and parties can decide their own arbitrator, but the arbitrator will not be of the same nationality as the parties. This is one I can recall.
And what about the Constitution of India?
So yes, sir, the Constitution of India does incorporate principles of natural justice.
Can you give some example of provision wherein you can see that yes, it incorporates this principle or maybe an exception of the same?
So one that I can recall is Article 14, which says there shall be equality before law and equal protection of law, which is in a sense a principle of natural justice. Second is Article 21, whereby legislative enactments, where the court has various times upheld the right to fair trial and the right against discrimination under Article 15. These are a few, I think.
Any exception to this? What are the principles of natural justice? How do you define them?
So there are three main principles. The first is audi alteram partem, which is here both the parties. The second is nemo debet esse judice in properia causa, which means that no person shall be a judge of their own cause. And the third is of giving reasoned or reasoned decisions or ratio decidendi.
Okay. So in the Constitution, can you see any provision which in a way is going against the principle of natural justice? Maybe an exception to it.
So may I take a moment?
Sure.
So one that I can think of but also has protections is Article 310, which says that every person shall be appointed at the pleasure of the President. This is the only one that I can think of.
And what is the protection therein?
So the protection therein is that if such a person is removed from their post, they cannot be removed except by a person who cannot be removed by a person who is inferior in authority than the person who appointed them, and they will also be get a proper hearing and will be given the reasons for their removal as well.
Okay, can that hearing be excluded as well?
Yes, sir. The hearing can be excluded. There are certain cases such as if the removal is because of their conviction in a criminal offence or where it is against public interest that the reasons be given to them or is against national security.
Right. And with respect to the powers of the president, you just mentioned that the president is having the power to remove at his own will. How is it different from the one we find in UK? And if we try to compare it with the powers of the president in the Constitution of India, what is the difference therein?
So I'm sorry, sir. I haven't studied the comparison between the two. I'll
Okay.
read upon it.
If I ask you what is the position of the president in the Constitution, what would you say about it?
Sir, he is the head of the executive in the country.
Head of the executive, in
Yes,
what
sir.
way?
Sir, Article 53 provides for the same. There shall be a president and the president shall be the head of the executive.
So, with respect to Article 310, it says president can remove any particular public servant at his own will, right? That is his powers basically. So, how does this power exercised? How is it this power exercised by the president in the Constitution?
So he exercises it with the consensus of the Council of Ministers.
Is it the consensus of the Council of
So
Ministers?
aid and advise. I apologize. Aid and advise.
Can you recall the provision in the Constitution which says so?
Uh, So I can't recall the exact article, but it says that the president shall act on the aid and advice of the Council of Ministers.
Okay, and if the advice is given, let's say the advice is given by the Council of Ministers to remove a person from the post itself, is it mandatory on the president to follow the same?
So he can return the advice for once, but if the same advice is given to him again, it is binding on the president.
Okay, in what scenario? In every scenario, the advice can be returned once?
So
Or is there any restriction on the same thing as well?
So I'm not sure. I apologize.
Okay. With respect to the newly enacted penal code, that is our BNS, there is one provision that is not yet in force. Can you tell me about the provision?
So
Rest came into force on 1st of July 2024, but one provision remained.
So I'm not sure. One that I can think of is regarding forensic examination, but that is in the Bharatiya Nagrik Suraksha Sanhita. I can't recall in the Bharatiya Nyaya Sanhita. I'll recall.
Can you recall last year there was a strike by truck drivers?
Yes, sir. Yes, sir. Yes.
Can you
Yes,
recall
sir.
something
Yes,
about
yes,
it?
Sir. I recall. So it says that in the offence of murder, if a person or culpable homicide by rash and negligent driving, rash and negligent death. I apologize. So in that section, it says that there are two special provisions that are given. The first is regarding doctors and medical professionals if they act in medical negligence, and the second is regarding if a person, in common parlance, what is called as hit and run. If a person hits a car because of which, or a vehicle because of which death is caused, and if such a person evades or absconds from there, then there is higher penalty, because the law provides the duty of this person is to inform the nearest magistrate or a police officer or magistrate outside the jurisdiction, but such a person must inform, else is subject to greater punishment.
Okay. So why is it not yet in force? Because it's a good provision. It will, it is meant to save life of the people who are hit basically by any car or some other vehicle.
So from what I can recall is that there were strikes by truck unions and truck driver unions and other cab unions, and because of which the union had promised that there will be consultation on the same, and only after consultation a consensus will be reached, and then this provision shall be implemented.
So consultation in what perspective? Because what is the lacuna? There has to be some lacuna for us to consult about it.
Although I'm not sure, if you'll allow me, I'll take a guess.
Sure.
So I think that it's because a lot of the times it's not the truck driver's fault, or they're subjected to a lot of pressure because a lot of the times if there's an accident, a lot of hue and cry is created and a lot of public assembles, and often that leads to the truck driver himself or like a vehicle driver himself getting injured. So because of that, I believe.
But the provision itself says as soon as possible. They are not meant to just stop at that place and then convey, right? They can report it afterwards, anytime which is convenient for them.
Yes, sir.
Then why this hue and cry?
So I'm not sure.
And how do you differentiate between the basic part of maybe rash and negligent death of a person and this hit and run without reporting? What is the difference between these two provisions?
So the former, that is rash and negligent death, is because of any act.
What is rashness and negligence?
So
what is the difference?
So rashness refers to knowledge that a ill consequence could happen, but hoping that it does not happen. And negligence is where there is a duty of care, and such a duty of care is breached, because of which in this case death is caused.
Okay. And how do you differentiate between the new provision?
I believe between hit and run and between rashness and negligence, hit and run is more specific in nature, because it deals with accidents that are caused on road because of certain rashness or negligence that is exercised on road. For example, drunk driving, or for example driving outside ahead of the speed limit, etc. And then this person absconds. Because then it is very difficult to trace such a vehicle or trace who did the offence, and oftentimes if it is in deserted places, then the victim dies because they do not receive adequate medical care which they could have, which they received, they would have survived.
Okay, so let's say a person was driving within the speed limit, right? He was not at all negligent or rash. He hit someone. Right. Some person is now on the road, the blood is being splattered everywhere, and without reporting the same, he left. the car driver left. Is any offense made out in this part?
So may I take a moment?
Sure.
No, sir, I don't think so. I'm not sure entirely of the legal provision, but I don't think so. Not in my opinion.
But then what is the difference here? And if we look at the provision itself, if it says
Sir-
hit and run and without reporting.
Sir, because there's no rashness or negligence involved in his conduct, it can qualify, if he can prove the same, it can qualify as an accident under section 80 if he was doing no wrong. Although he can be charged with the offense of the culpable homicide or rash and negligent driving, but if there is no rashness, as you said, then he can take the defense of accident, and so no offense will be made out.
This is why the provision is not yet in force.
All right.
Because otherwise, if a person reports,
Yes, sir.
it becomes a problem for them.
Yes.
That means they are in a way trying to accept that they were rash or negligent in their part. That's why it is not yet in force.
Understood, sir.
So apart from this, you have talked about culpable homicide and murder a lot. What is the difference between these two?
So the difference is of severity. Culpable homicide.
Let's just talk about section 100 and 101 thirdly. Thirdly of 100 and 101 fourth.
So, thirdly of 100 talks about when an act is done with the knowledge that it is likely to cause death, and 101 thirdly talks about when an act is done with the when act is done with the intention of causing an injury that must cause death in all circumstances or in all probability. So the difference is of degree, where in culpable homicide a person just did an act which he thought or had knowledge that this act could cause death, whereas in murder the act is done is so grave or so dangerous that it would have caused death in all possible scenarios. So the degree of knowledge as well as the degree of intention of causing injury.
Is it intention or knowledge? Because you are repeating the word intention.
So both. Because thirdly says intention to cause a bodily injury.
I'm talking about 100 thirdly
Yes, sir.
and 101 fourthly.
So 100 thirdly talks about knowledge, whereas 101 thirdly talks about
Fourthly. 101 fourthly.
Fourthly is only knowledge, sir.
Yes.
The act fourthly is only knowledge.
Right.
That act is so imminently dangerous that it must cause death in all circumstances.
Right.
So-
So let's say a person is standing on the fourth floor and you were behind that person and you pushed him from that fourth floor. The person fell down and that person died. Will it come under 100 thirdly or 101 fourthly?
Um,
You did that without intention,
yes, sir.
but it was not a mistake.
Yes, sir. Understood, sir. So I believe it will come under 100 and under 100 fourthly, sir.
100 fourthly. Why so?
Sir. Sorry, 100 thirdly, sir. I apologize.
100 thirdly.
Yes, sir. That's because a person falling from a fourth floor might have a chance of survival. It is not necessary that the height is, I believe that the height is not so high that it would certainly cause death. There might be injuries. The injuries might be also very dangerous, but it's not absolutely necessary that death would be caused.
Okay. Can you recall 101 fourthly where it says without any excuse? The very last part of section 101 fourthly.
Yes.
Can you explain that part? What does that mean? Without any excuse. What excuse are we talking about?
So I can't recall the exact provision. I apologize, sir.
Okay. 101 fourthly, it says that when a person does any act with the knowledge that it must in all probability must cause death, right? He has done that act without any excuse.
Yes.
Then it falls within 101 fourthly.
Okay, sir.
What is that without any excuse? Which excuse are we talking about?
So I believe because 101 fourthly says that the act is very, very, very dangerous or very imminently dangerous. So a person cannot, this section says that the person cannot have any excuse or any reason for committing such a dangerous act. That is what I think, sir.
Right. Which excuse are we talking about? For example, let's say a person was trying to kill someone. That's why he was trying to drive the car at a very rapid pace. And he drove the car into a very crowded area and there, with every knowledge that the person is having, drove the car very fastly and smashed 2 or 3 people, crushed them. Now herein, is there any excuse? Is this the excuse we are talking about? Is it the right of private defense that we are talking about, the excuse? Or is it something else other than that?
So I believe it should be an excuse other than private defense, because if it's private defense, then it is subject to general exceptions, and also subject to the exceptions laid down in section 100 itself, 101 itself. So I believe it's some other excuse. I'm not exactly certain, but
Okay.
yes.
What are the exceptions in 101?
So there are 4 exceptions. The first is that if the act was done by virtue of grave and sudden provocation, where such a provocation was not self-induced and was not due to a public servant exercising his lawful duty or a person exercising his right to private defense. The second is when a person exceeds his right to private defense and causes death. The third is where...
Kindly explain this one. Exceeds the right of private defense.
Yes, sir. So every person has a right to private defense. However, the private defense is subject to section 99 of the Indian Penal Code, as well as where death can be caused has been defined under section 103 in cases of for right to property, private defense against property, and for body under section 100. So if a person, if an offence does not fall in the ambit of 100 or 103 and thereby death is caused, or if a person exceeds the right contrary to section 99, the statutes of section 99, that is what I believe is exceeding the right to private defense.
Right. So, sir asked you a question regarding the stabbing of Saif Ali Khan. What provisions of the Bharatiya Nyaya Samhita have been made out? Apart from this, if there is any other law, let's say law of torts, what all the tort have been committed?
So I apologize, I can't recall the exact provisions of Bharatiya Nyaya Samhita, but if you allow me,
Or you can just tell me the offences. That's fine.
So it's attempt to murder, I believe, because a sharp weapon was used, and at a lot of vital organs. He was stabbed at, including his spinal cord. Apart from that, trespass, the offence of trespass shall be made out, which is also a tort. So defense can be taken in tort, so action can be taken in tort also for the same.
Is it trespass or criminal trespass?
So both shall be made out. If it's tort, then it shall be trespass, and if it's criminal law, it shall actually be housebreaking or house trespass. However, I'm not sure how he entered. Apart from that, sir, I can't recall something else.
Okay. What is the difference between trespass and criminal trespass?
So trespass is a provision in the law of tort which says that if a person enters or stays in the property belonging to another, and only if this is done, the tort of trespass is made out. Whereas the offence
Where
of
a person, you just said, where a person enters into the property of another.
enters or stays after having lawful authority to enter, he stays unlawfully or without the permission of the other person, without any reasonable excuse. That is the tort of trespass. Whereas in the criminal trespass, it is the trespass is done with the intention to commit an offence or with the intention to insult, annoy, or intimidate the possessor.
Right. Okay.
So Samridhi, I will be asking you a few questions from civil law. Can you tell me the cause of action involved in a suit of interpleader?
Yes, sir. So, an interpleader suit is under section 88 of the Code of Civil Procedure, and the cause of action is essentially that a person holds a property which several persons are claiming adversely to one another, and the person who holds the property does not know who the rightful owner